It's time for Ask Mike Mondays. Mike answers one listener's question every week. Here's Michael Becker and Paul Peebles.
Welcome to Ask Mike Mondays. I'm your host, Paul Peebles, National Underwriter for Old Capital, and sitting across from me is Michael Becker.
Hey, Paul.
The governor of apartments in Texas. He is the man himself. Michael, as you know, the former banker has gone from loaning money to now owning real estate. He has closed 29 large apartment complexes in the state of Texas. So he definitely knows what's going on. 6,200 apartment units closed, Michael?
That's right, yeah.
And over $150 million in capital raised from investors just like you, wanting to know a little bit more about how to invest in apartments. So we're here to kind of tell you a little bit about what's going on. So Ask Mike Mondays. I thought we'd go right to it. So here is a question. Hi, Mike. I'm currently syndicating a 100-unit property near Orlando. We were a week from closing with all funds raised, and the seller asked for an extension for internal legal issues, which we accepted with a discount. Have you ever had a situation like this where the seller did not close and you had to go to court to close? How did you manage investors while legal got closing resolved?
No, I haven't, fortunately, but certainly you have contracts for reasons, and there's reps and warranties, and there's certain remedies for situations like this. And, there's not only when the buyer defaults, there's certain remedies, which usually it's you lose your earnest money. That's typically the first remedy. The second remedy potentially could be they sell for specific performance where they could sue you to, force you to buy the deal. But usually most of those have a cap on kind of damages to what your earnest money is. Then the flip side is true. If you're in escrow and you're trying to buy a deal and the seller defaults, so what do? So you got to kind of look to the default section and kind of what your remedies are. So usually you typically will get your earnest money back, and then there'll be a cap on damages in most of these contracts. So these are things that most people probably don't pay a ton of attention to because they don't matter 99.9% of the time. But when they do matter, they matter. So, if you're out there, you've raised a bunch of money, you spent money on your PPM, and you spent money on inspections and lender fees and maybe even rate locked your loan. You could be racking up hundreds of thousands of dollars in expenses that the seller defaults, and you're kind of out this money. So looking to what the caps in your contract for seller defaults are certainly something to pay attention to. That's kind of what I'd point you to, because that's why you have a contract. So the contract will tell you what you can and you can't do along the way, and then and if the seller defaults, and how much money you can maximum you can go after them for.
So again, it's a little bit of a timely question. And so it really comes after the thinking is how to get sued for non-performance. And so one of the things I think we've mentioned on the podcast before is that one of our buyers was under a purchase sale agreement. They were buying an apartment building and the seller signed it. The buyer pursued all of his methods to buy the property, did his due diligence, did his loan, raised all the money, put hard money to lock his loan, goes to the closing table, finds out that the seller does not have the right to sell the property because the loan that he had on his property had a year and a half, 2 years of a lockout, which means that they couldn't do anything. They couldn't refinance it, couldn't sell the property, so they had to stop the process. So that not only pissed off the buyer, but it found the seller in court by the buyer. He still wanted to buy the property, but he wanted to also get his money back from his investors. And that was a couple $100,000 that they used in pursuit costs. Second one was just recent. How did he get sued? Purchase sale agreement signed, middle of the transaction, appraisal ordered, we're ready to go. It's an exchange deal. Seller has his building caught on fire, and now he's screwing around trying to figure out is he going to repair it himself? Is he going to transfer the proceeds? Well, he tried to repair it himself, and his insurance money was for $350,000, but he was trying to get it done for $200,000, and he was going to try to pocket the difference on his way out the door. So here's an insurance claim for $200,000, and I'm trying to do the work myself or get somebody to cut rate to do the work. So they weren't able to get the transaction done. Another seller found themselves getting sued. Last one is just really recent in the last week or two. We had a seller and a buyer trying to buy the property, $500,000 in a fire during the purchase contract. So everything gets signed. We do all the work to get all the due diligence done and the loan done. And then all of a sudden the property has a $600,000 insurance claim against the property. Seller again wants to try to do the work in the property. and buyer wants to take over possession. And it's not going to probably go, hopefully to go to legal, but you need to transfer the insurance proceeds to get the buyer to buy the property, to get the work to be done. So just be very, very sensitive on these deals where you have to follow the rules of what the contract says. If something happens during the 60 days or 90 days to get this deal done, make sure you do your part to make sure that you don't get sued for not following through. So, just some stories off track.
Yeah, the contracts are there for when things go wrong. So a lot of these things don't, like I mentioned, never ever come into play. But when there's an issue, that's what everyone defaults to. So paying attention to that, making sure you understand the default clauses, the casualty clauses in the purchase and sale agreement.
Get yourself an attorney that is a contracts attorney. Don't use a regular general practicing attorney that may handle trusts or wills, may not be familiar with all the legal ease. That is so critical for somebody that's just getting in the business. Get yourself a real estate contracts attorney. You can probably talk with the bar association in your local town to figure out who that person is. They always kind of show what their specialty is in some of the websites that they're practicing on. Find a real estate contracts attorney and then pay the big bucks. Don't go cheap on that, because in case something happens, and I've named 3 things that have happened recently that you just want to make sure that you're covered, and listen to them, making sure that they put in those safe harbors for you. So anything else?
That's really it.
So if you wanted to get some more information about what Michael does and his group at SPI, what's the best way for clients and people to listen to that want to touch you?
Yeah, the easiest way to find more information about what we do at my company is simply just go to our company's website, which is www.spiadvisory.com. That's SPI like spy advisory.com. There's a contact us form, and I'm always happy to have a 10 or 15 minute telephone call with listeners of the podcast.
That's great, Michael. We appreciate it. Again, I'm Paul Peebles. I was Michael Becker. Have a good day.